we're on the air here with Chapter 5 on dispute resolution in the American courts. Welcome, and again, this chapter covers a wide range of both trying to stay out of court and what happens once we get into court. So here's the basic objectives for you for this chapter. You should have a good understanding of what alternative dispute resolution, it's abbreviated as ADR, what that entails. There are a variety of types. We'll go through these, but negotiation, mediation, conciliation, arbitration, many different ways of staying out of court. We'll talk about the advantages and disadvantages of going through those various types of alternative dispute resolution. And then we'll look at the U.S. court system in detail, and generally the overall structure of the courts. We have a state and federal court, two different systems, or two separate systems of courts. Just like we talked about in the chapter on the Constitution, and at the very beginning of the quarter, we have a federalist a system of federalism in our country. So that means we end up with a state court system and a federal court system that overlap in many ways. And then, so you should know the basic structure of each and jurisdiction of how you get into each of those courts. We'll talk about civil procedure in the U.S. courts and what that basically means, what the process of a case would entail from the very beginning, from filing your complaint all the way up to and including going into trial. And this is in civil matters, not in criminal cases, but in civil matters we're talking about. This is probably a total of about 35 slides in the PowerPoint, so we'll break this up into two parts, and this is part one. We'll stop probably around slide 18 or so, just to give you an idea of where we are so you can see this in parts, okay? Right. So you suppose you buy a new bicycle, and you're out riding, and there's an accident, one form or another. You have plenty of options what you can do. What would you do? Often the choice, the sort of stereotype, I guess, in a way, but it bears itself out in some data. There are a lot of lawsuits, probably per capita. In the United States has probably more lawsuits than probably anywhere on the planet. And so our natural sense, we want justice, we feel we're entitled to go to court for cases, and people have. And so just so you know, give you sort of a ballpark, in civil cases, probably about only 5% of all the cases that ever get brought end up in trial. So we're aware that the court system, the courts themselves, are very backlogged with cases. That should give you the idea of the volume when you consider that only approximately in civil matters about 5% end up in an actual trial in a courtroom. Most are settled along the way, long before, or they're dismissed long before they ever would reach trial. All right, so this whole idea, alternative dispute resolution, is basically trying to get to a point of not going to trial. So how can you avoid getting in the courtroom and still have your dispute resolved? And these are the variety of ways, which we will go through all of them, but negotiation, mediation, conciliation, arbitration, mini trial, and then judicial referees, which are also part of this potential process. So here, we'll start with negotiation. So you have a dispute with someone. One way to do this, to resolve it, is to try to negotiate it as opposed to, going to court. And you could still have a lawyer in this situation, and you have two parties that are present, and they may or may not have attorneys. Certainly, if you have, if one party has an attorney, it's probably recommended that the other one does too, just to be sure that your legal interests might be represented. But this is, again, trying to avoid cost and time. That's the most significant reason why people choose these methods, is to not rack up attorney's fees. And businesses often will do the same thing because it's very expensive to go through this procedure, to go all the way to court, and filing lawsuits and all that's involved in it gets expensive. So negotiating is one way to try to resolve your way out of this. And you can do this with two parties apart by way of a letter, by having the two parties together and chatting this out across the table, and you basically negotiate. You try to peacefully hammer out your result. And this is better in lower dollar value cases. I've seen this in divorce cases where people are fighting over the toaster, they're fighting over other smaller assets. They might have some some sentimental value, but I've reminded clients, you can keep fighting over this toaster, but it's going to be a $5,000 toaster pretty soon because the attorney's fees keep racking up. So it's easier to negotiate, to sit down and be reasonable about those things in a lower dollar value case. In a more complicated case, you get something like a patent infringement case. It's probably less likely to do this when somebody's arguing about the patent over their invention and they feel like someone else has, or another company has, stolen their idea somehow. Probably a little less likely to be able to negotiate your way through those types of cases, but not impossible. There's still a way. And another alternative here would be mediation, and you have a mediator who's technically as a non-interested party who's going to meet with the parties separately first and hear each party's side of the story, and then meet with them together and make a recommendation. And it's a non-binding resolution to the decision that comes up from the mediator. In some cases, I know, California and family law cases, they require that there's mediation over certain things. Some issues, child visitation or those types of things have to be mediated, and the mediator is supposed to come back with a reasonable result. But what's key here is it's a non-binding resolution. So the parties, what you're really trying to get at here is trying to keep the parties communicating and lowering the tension involved in the case. But one party can walk out the door and do the exact opposite of what the mediation agreement says, because a non-binding resolution. Now, it doesn't look good for the judge, for the party who is following the agreement later on goes to court, and this party totally violated the mediation agreement. It doesn't look good for that party, but the fact of the matter is it's not binding. Okay, so the parties basically are the ones who bargain back and forth, and then they're involved in the resolution of this matter. Conciliation is a little bit different, similar but different in this sense. Similar in that there's a neutral party who plays a role like the mediator did. The conciliator is neutral, and in this case, the conciliator is less passive. The mediator is not driving the bargaining and mediation often. The conciliator, on the other hand, is more actively involved and is really trying to make proposals on settlement between the parties. So the conciliator is the same kind of, pardon me, I didn't mean to do that. The conciliator is trying to get at a result for both of the parties, but the conciliator is much more active, involved in coming up with proposals and saying, hey, look, this is what's likely to happen if you were to go to court, and let's draft up something that we can both parties can agree to. Again, not a binding result on this, and so parties can walk away from this and do something different. Although, as I mentioned with mediation, it doesn't look good for you in court if you totally violate the spirit and that which is made in the conciliation agreement. Basically doesn't look good for you to have violated that, but then it's not binding again, like mediation is not binding either. Okay. Arbitration, and then mandatory arbitration, you have this mandatory, it's mandatory sometimes because it's in an employment agreement. Certain employment agreements, when you are hired as an employee, say if you have a dispute with a company, if anything ever happens, rather than going to court, you must go to arbitration. And it's mandatory. There's not an option about it. I've known people who've been injured on the job, and the company's clearly liable, and they wanted to file a lawsuit against the company, but they couldn't do it because their employment agreement said that they were required to submit the case to arbitration. What's arbitration? Arbitration is just like you've seen with mediation and conciliation. You have a neutral party who's a third party. They may be a retired judge. They may be a retired attorney who's people who are experts essentially in that field. We have the American Arbitrators Association. There are a number of international organizations too with arbitrators that basically will hear cases. And the difference between the other ones we've talked about so far in the ADR is that what comes out of arbitration is binding. And it's like 99.9% of cases. There was a case not long ago in, I think it was South Carolina case that ended up going to the U.S. Supreme Court, and it was the decision was overturned, but the vast majority of arbitration decisions are final. So when you sign agreements, it's important for you to look at this. Who writes the contract when you buy a certain product? Who writes the employment agreement when you go to get hired at a new job? You don't. And so you will see often businesses are, because they're trying to save time and money, it's significant. This is why we're talking about ADR versus going to court. A lot of businesses, it's a good business practice to say we don't want to submit our case to a court and a jury and all that. We'd rather have a retired judge or somebody who's an expert in these cases to come up with a reasonable decision that's binding on both the business and the party. So something that's significant here. So they are rarely appealable, as I mentioned. One U.S. Supreme Court case, like I said, I think came out of South Carolina, and that was appealed, and it started with an arbitration agreement, and people tried to say it was inappropriate, and the U.S. Supreme Court agreed, and it went back through the court system. So again, businesses sign arbitration agreements, employees sign arbitration agreements. There may be clauses in a contract, and even a clause in a contract that might say, and you can do this if you agree, both parties agree when they sign the contract, we want an arbitrator to decide the decision, but even an arbitrator's decision might be appealable. Both parties could agree to that, but that's fairly rare. From a business standpoint, two businesses are entering into a contract, and ABC company and XYZ company, if they have a legal dispute, one's a supplier and one's the purchaser of certain products. If they have a dispute, it's in both their interests, rather than having to go to court and spend the money of court, to have a quicker resolution and less expensive resolution of a matter in arbitration. So they may be in a clause in a contract, and you may even. So I mentioned employment agreements. Pardon me, I mean to do that again. Employment agreements. Often businesses will put this in just for their employees, and that's a critical point here too. Okay. All right, the American court system. I think I mentioned earlier in the quarter we talked about this in class, and the old English common law system was what appeared to this day to be very strange ways of dealing with cases. But they had trial by morsel and trial by ordeal. These ways of how do we handle this dispute today? Well, we look at cases that we've had in the past, and the trial by ordeal was you held something hot in your hand, it burned you, and if you became infected, then you must be the wrong party or something, you must be guilty. Things like that were, if that was the common practice, that was done. Well, our system has obviously developed since then, and this notion of what we consider to be the rule of law, anywhere if you look across our planet, countries that are deemed to have the rule of law have a relatively fair and just court system. And what by fair and just we basically mean that there's not the discretion allowed by a judge, or not the like a king being able to decide exactly what the result of your case is. And the king or the judge, one person might have a very biased view of the situation, and so the idea of having a jury in certain cases and having a system that enables people to get their day in court, to confront their accusers in criminal trials or in civil trials, to have their civil dispute handled in an unbiased manner is significant, and so the rule of law, that term applies to systems that have a fair and just civil procedure type of system for civil cases and also for criminal cases. So trial courts. You haven't been successful in the alternative dispute resolution aspect of things, and so we'll be getting in a second here to the procedure of getting to court. Although I probably should go back. I think there are a couple other terms on there: mini trial and judicial referee, which we didn't talk about in the ADR sense. So I'm going to backtrack for a second. A mini trial, essentially, two companies, let's say, have a dispute. and the two companies, rather than go to trial, they have essentially a mock trial, and they have selected from the public some arbitrarily selected people to be on the jury, and they get to present their case in a mock trial court. And they present their case, and then the parties, after this mini trial takes place, they get a jury verdict, and then there's some evidence of what's likely to happen in a courtroom with the case, and so they may come to a resolution after that. Sometimes you might have a judicial referee who acts as an independent party to resolve a case, and those people are hired essentially by the parties, like arbitrators are selected by the parties from a list of people from the American Arbitrators Association, let's say, and judicial referees have that same kind of a role, essentially. So we're proceeding to the court system, and we'll get to the whole civil procedure process in a few minutes here as to what happens from filing your complaint and going on to trial. But this is getting at our structure of our courts and what takes place in courts. When we talk about trial courts, we're talking about the first court that you go in when your case is pending, when you filed your case. So in a civil matter, generic term, sort of very general term, we could refer to every court, no matter what their specific name is in state or federal court. The first court that you enter would be considered a trial court level, as compared to an appeals court where you've already had a proceeding that took place and somebody lost and they filed an appeal, which we'll get to in a minute. But right now we're just talking about the very first level of courts that you would enter. And in the trial court system, whether it's just a judge or whether there's a jury also, what's considered what's the law of that jurisdiction? What's the law required to be followed in that particular location? And what are the facts? And the facts, when we talk about this from the beginning, there's a bicycle accident, something happens, and then what are the facts in the case? How does the law apply to the facts? And then there's a decision. The decision is made by a judge if it's a judge-only case, or if there's a jury that's requested in civil matters, you can request a jury as well. Basically, the expert on the law is considered, lawyers might consider themselves to be the experts on the law in a particular case, but the ultimate expert on the law is the judge, who listens to the facts and determines who's telling the truth and what is the truth of the case is the jury. And in this case, there's no jury, then it's also the judge listening to the facts that are presented, and those are the evidence that's presented. It could be photographs, it could be x-rays, it could be statements by witnesses. It's all of that, right? So applying the law to the facts in this case, then we come up with a decision. That's the routine process in trial court. Now, if one party loses, then you appeal. So you ask for a higher court. You don't have to, but you may ask for a higher court to hear your case. And what's significant here, no matter what state court or federal court we're talking about, an appeals court basically makes one decision at the end of the day. You're appealing. You're asking for this other court to review the decision that was made before. And what this appellate court is doing is they're not going to go through all the facts again. Okay, they're not going to listen to all the testimony from witnesses. They're not going to, hear somebody say, well, this person ran the red light, or here's the X-ray of the broken wrist, or whatever it is. They are determining at the appellate court level, the one question they're answering ultimately is, did the court below, the trial court, did it make an error interpreting the law, applying the law to the facts in that case? So you have typically, it depends on the jurisdiction you're in, 30 days from the day you lose your case or you're unhappy with the result of your case. Even if you've won, you can still appeal. You might win and not get enough damages that you think you're entitled to, money damages. But you have a time limit in which to file your case. If you are 1 day past that limit, you are out of luck. You have to show some really extraordinary reason why you didn't file. And in many cases, we've had even Washington State cases where as high as the Attorney General missed the filing deadline for an appeal on a case where the state lost millions of dollars. When it came to the filing deadline to refile their appeal, they missed by a day, and the court said, "Sorry, you're not different than anybody else, so you are out of luck." And so we had a multi-million-dollar judgment the state lost because we missed a filing deadline for the appeal. So here, what the appellate court is looking at is, yes, they're again looking at the law. Like I said, they're trying to see if the trial court level made a mistake in interpreting the law. They don't have the facts in the sense that they don't have witnesses, but they look at the court reporter's typed record of all of that. So they can look at the record, but they're not hearing new testimony at all or a repeat of testimony. They're looking at what actually is represented as from the facts and applying to the law. And they don't get the facts in the sense, like I said, from witnesses. They have only the record to look at that's already been recorded. They can examine that, and they can examine specific evidence, a photograph or something like that. But typically, they're looking at based on the determination of the court below, the trial court, did they apply the law correctly? That's the ultimate question for the appellate court. Right. So trial courts and appellate courts, I'll just put this up. I'm going to put all these up here. Just briefly, just so you have an idea of the, the names we're referring to here, or the titles. So the parties at the trial court level are called plaintiff and defendant. Sometimes, depending on your courts, if it's like family courts, some family courts will require petitioner and respondent. In the trial court level, your decision maker is going to be a judge or a jury, or the judge and the jury. And then essentially your person can be a judge, or they're titled as magistrate or commissioner. They have different titles as who's going to help to decide the case. At the appellate court level, your party names change. Whoever files the appeal is typically called the appellant, and the party who is not filing the appeal is called the appellee, or sometimes they're the respondent. They're responding to the appellant's claim of appeal. The appellant says that there's a mistake on the law below in the trial court below, and the respondent's responding, or the appellee is responding. Sometimes, that title can be petitioner and respondent on appeal too. And the decision maker in these cases on appeal is typically a number of justices. I'm not sure, there may be cases where there's one or so, but usually there's you have several judges, an odd number, so that like you have three or something that listen to a case. A whole en banc group of judges might be significantly more than that, but the appeal judges are judges, it's usually plural, are making this decision, looking at it. And they might have different titles too, commissioner, magistrates, but they're typically justices or judges. Okay. And again, the attorneys argue both cases here. Witnesses testify at trial court. There are no witnesses to testify on the appellate court level, although, again, as I mentioned, there is the record from the lower court. Evidence is introduced. There's no evidence other than the record that's introduced at the appellate level. Questions of fact get decided at the trial court level, and again, there's no question of fact that's decided. It's only the trial court record that the appellate court gets to look at. And so here's just another thing. The questions of law are decided. Questions of law are both decided in both cases. New law is not made in the sense the trial court has to apply precedent, which is usually the appellate court or the highest appellate court in that particular jurisdiction, which is usually a state Supreme Court. They also have to apply the federal court rulings, the U.S. Supreme Court. They have to follow those decisions. And yet here the appellate court level can make new law and does make new law. The state Supreme Court can decide that based on state law and based on prior precedent is going to apply the law in such a way that it creates new law. Now, this gets into a big debate with some people because they don't believe that the judiciary should be making law at all. They should say that if any new law is made, new law should be made by the legislative branch. And so there's a big debate about this, but the fact of the matter is courts rule all the time, and the highest appellate court ruling in each state, state appellate courts often rule that is in a way that creates new law for that particular state. And as long as it's not in violation of federal law or the Constitution, then usually that's not a problem. Even when a U.S. or a state Supreme Court rules and it is creating new law, parties do bring those cases to the U.S. Supreme Court to say that they're in violation of some federal law or the Constitution, and there's that decision can be overruled by the U.S. Supreme Court. Okay. All right, looking at the structure of courts now, I put up the Washington State court structure. Some of you have this in the back of your textbook if you have the new textbook with the dominoes on the front of it. Some of you do not, so this is an area that you have this document available for you. I'm never going to test you on the number of judges or the number of courts in a particular jurisdiction. What I'm showing you here, just by way of overview, is that the overall structure, and most every court in the or every state structure in the country matches this. You do have some odd things. I went to law school in New York, and New York's got a very strange system where where we have the Superior Court, which is a court of general jurisdiction, which I'll explain in a few minutes here. Our Superior Court actually in New York State is called the Supreme Court. So they have multiple Supreme Courts across the state of New York, and that's their lower level general jurisdiction courts. And then the Court of Appeals in New York is actually the highest. That's the title of their highest court. So they're very odd in that sense, but most every other state in the country has this system of courts of limited jurisdiction, which basically when we say limited, the bottom district court and municipal courts in Washington State they're limited in terms of dollar value, and if it's a criminal case, they're limited in the sense of severe crime. So if it's a smaller dollar value case in a civil matter, and it's more of a minor case, misdemeanor case, or even a driving while intoxicated case, but no property damage or personal injury, those cases can be heard in a smaller court, not smaller physical court, but a lower level court, such as a district court or a municipal court. And it depends entirely on the jurisdiction that you're in. Whether it is a district court or a municipal court. I believe in Shoreline, it's a Shoreline Municipal Court. That's the court that would cover the area. District courts, depending again on what area of Washington State you're in, you would have that. But courts are limited jurisdiction. They're limited in the types of case that they can hear and the dollar value or severity of the crime. So they're usually more minor cases. If you have a more serious case, there's a felony, you've robbed a bank or something like that, or it's a dollar value case that's significant, then those cases start in Superior Court, right? If you lost one of your district court or municipal court lower level cases, then those cases could be appealed to the Superior Court. Otherwise, cases involving divorce and felony cases and those types of things, dollar value cases that are extreme, those would start in the Court of General Jurisdiction, which is our Superior Court. If you lose there, you file your case to the Court of Appeals, and the Court of Appeals is considered generically as an intermediate appellate court because it makes a decision, and even that decision can be appealed to our U.S. Supreme Court, and they say court of last resort. That's the highest level court in our state to make a final decision for our state jurisdiction. If you lost there, you could still potentially appeal all your way to the U.S. Supreme Court, depending on whether the Supreme Court takes your case or not. But that's not the end of the story, but that's the highest court within the state court system. Now you see a line between our Superior Court and the arrow on the left side in the Supreme Court here in Washington State, and that is for certain types of cases. You have not long ago we had a Supreme Court justice from Washington State that was involved in a drunk driving accident and a hit and run in Ballard. Her name is Bobby Bridge. She drove away from the scene of an accident. I think her blood alcohol level was just astronomical, and I can't remember what it was, like 0.2 0.26 or something crazy, 0.18 or something. She was well above the legal level. So the case is a hit and run. When you're potentially as a judge or an attorney, your cases can go straight to the Supreme Court, and they hear those directly from Superior Court. The action's brought in Superior Court, and then it carries up to the Supreme Court, and it's just a matter of course of how those get handled. So, and there's some other cases the Washington state constitution will label which ones would go through that. But this is the general structure, so you should understand what courts of limited jurisdiction mean, what the court of general jurisdiction is, the intermediate appellate court level, and the court of last resort. All of those are what we're talking about with the Washington state court system, and a very similar structure in most every state in the country, with a few exceptions. The federal court system, and again, I'm not going to quiz you on the exact numbers of judicial districts and numbers of courts of appeal and all that, but this is the basic structure. The trial court level in federal court, the first court you could bring your case into would be called district court, and every state in the country has at least one. Depends on population of your state. Larger population states have multiple district courts. Like California, Texas, Pennsylvania, New York, many those have multiple district courts. Our own Washington state has 2 district courts. We have a western district, which is located in Seattle. We have an eastern district located in Spokane. So if your case was a federal related case, we'll talk about jurisdiction here in a few minutes, but if it was a federal related case, you could, and it happened in east of the Cascades, you're likely to be in Spokane. It would be where you would bring your case in federal district court, the Eastern District of Washington. If it happened in King County, you'd bring your case in the federal district court in Seattle. So every state has at least one district court. If you lose there, you file your appeal to a circuit court of appeals. Circuit court of appeals, I'll show you a map here in a second. It says here it has no original jurisdiction, so you can't start there. You have to have lost in a district court somewhere in a federal district court across the country. And then you go to one of the circuit courts. In the circuit courts, there are 12 of them, and they are essentially regional courts. Ours, we are located in the 9th Circuit Court of Appeals. The 9th Circuit is where we are, so the 9th Circuit Court of Appeals physically is in San Francisco. So if you lost your case and filed it in Seattle at the Western District of Washington and you lost, you would file your appeal to the court in San Francisco, which is the 9th Circuit Court of Appeals. And if you lose there, then you would appeal up to the top, the Supreme Court. And the Supreme Court, is in Washington, D.C., as you all know, and it has limited original jurisdiction. So what that means, the case could only originate in the U.S. Supreme Court in very limited cases. The Constitution spells that out. If an ambassador of the United States, if a governor, I believe, if a state is suing another state, if Washington sued, let's say, Oregon over Columbia River water rights or something like that, those cases start in the U.S. Supreme Court. There's a very limited number of cases that are like that. As I said, they're spelled out in the Constitution. Otherwise, cases have to follow this normal process of district court, the Circuit Court of Appeals, and then to the Supreme Court. Okay. So these are the circuit courts. You can see we're Alaska, Hawaii, California, Nevada, Arizona, Idaho, Montana, Oregon, and Washington are what we have for all the 9th Circuit Court of Appeals. So these circuits are all in regions here. And ours, as I mentioned, is located, the actual physical courthouse is located in San Francisco. The 10th Circuit is physically located in Denver. And then you look at the 7th Circuit, you've got Wisconsin, Illinois, and Indiana, just those 3 states, and the 7th Circuit Court of Appeals is located in Chicago. All these regions have their own specific Circuit Court of Appeals to represent the cases that are heard, federal cases that are heard within that circuit that are appealed to them. Okay. So the federal courts, I'm going to put all these up here. The federal courts, there are a number. These are created they're created ultimately by Congress. The Constitution enabled, it created one Supreme Court and then enabled Congress to be able to create other inferior courts. And so these courts, you can tell by the name of each of them, they all specifically relate to issues that have come up over time, and the Congress thought that we should have specialized courts to deal with these types of matters. So tax court court if you had felt that your taxes were inappropriately charged. You had back tax revenue that you owed the IRS. You would bring a case and ultimately go into U.S. tax court. You had a claim against the United States because the United States had done something harmful to you. You actually could sue the U.S. government, and you would bring in the U.S. Court of Claims. If you had an international trade case, international trade problem, U.S. Court of International Trade hears those cases. And if you're going to file your case in bankruptcy court, that's where you file it. Your bankruptcy court, your business is failing and you can't pay your creditors. You file your case. It's a federal case, not a state case. Bankruptcy court is a federal court, and that's where you would file it. So I think where we are, yes, I'm going to stop at that point, and we will pick up part 2 shortly after here. Okay.